Alright, hello, this is the last video for today. I have lots and lots of other videos on the site, but we're going to close off with a brief discussion of various kinds of dispositive motions, and I'll also do a brief comparison between Rule 59, judgment as a matter of law as compared to motion for new trial. And one of the reasons, I have two reasons for being brief. The first is we've been going 3 hours now, everybody's getting tired and we can't cover everything in detail. And the second is the stuff I'm about to show you is on my website. So I can blow through this kind of quickly, and then you can go to my website at nathenson.org and then look at it for yourself in more detail. To understand the difference between various motions, what you want to do is consider the differences in terms of timing and purpose. So Rule 12b-6, motion to dismiss, materials, timing, purpose. All right? A 12b-6 motion to dismiss, the materials are going to be in the face of the complaint, right? Face of the complaint. We assume the well-pleaded facts to be true. Timing. 12b-6 motion can be done through trial technically, but as a practical matter, it's usually be very early in the litigation, right? And the purpose is gatekeeping. Get rid of claims that are legally or factually frivolous. Easy. Well, Iqbal's not that easy. I'm going to skip over 12c, move on to Rule 56. Motion for summary judgment. The materials. Discovery materials, disclosure materials, affidavits, and more. All right? Materials. So now we're going well beyond the face of the complaint. In fact, an unverified complaint doesn't really count for summary judgment anyway, because it can't be used at trial, right? Instead, affidavits, discovery, and disclosure materials, as long as they be admissible, as long as they're either admissible at trial or reflect material that can be reduced to admissible status at trial. It can be up to 30 days after the close of discovery. And in fact, summary judgment is usually not ripe or proper until both sides have had an opportunity to do discovery or submit affidavits and the like. The purpose. Again, gatekeeping, avoiding the need for trial when there's no genuine dispute regarding the facts that are relevant or material to the claims or defenses. Now let's compare that to a 50A and a 50B. Our Rule 12 motion is, do we need to proceed to discovery, right? Or is this claim just frivolous? Rule 56 usually means we've had discovery. Now, are the facts disputed? If they are, then I guess we need a trial. If they're not, we don't need a trial, and the judge can decide the case as a matter of law, right? With Rule 50 motion, that kicks in when there is a trial, right? And the difference between 50A and 50B is a 50A motion is like it's directed verdict, right, by a different name. We are having a trial. The trial is ongoing, and the opposing party has been fully heard on the issue. And the question is now that the opposing party has been fully heard, do we really need to submit this issue to a jury, or must a reasonable jury find only one way? If the answer to that question is latter, the jury must find for the moving party, then judgment as a matter of law may be appropriate, right? So it's gatekeeping of a different sort. It doesn't prevent discovery. It doesn't prevent trial because there's been part of a trial, but it prevents that issue from reaching the jury, right? Compare that with a 50B, a renewed judgment for motion for judgment as a matter of law, all right? That means there's already been a jury trial. It's been submitted to the jury. The jury has issued a verdict. And now the judge isn't asking whether we need gatekeeping. The question is now, do we change the verdict, right? Do we take the verdict away from the winning party and issue a verdict for the other side, right? So it's not a gatekeeping matter at all. And in terms of timing, a directed verdict under 50A is after the non-moving party has been fully heard on the issue, but on after-trial 50B, also known as a JNOV motion, is after the verdict, right? Up to 28 days after the entry of judgment. All right? Now, an important thing to keep in mind, and this I raise because I think it's hugely testable in the bar exam, is two things about a 50B renewed motion for judgment as a matter of law, or a J&OV motion. First, you can't have a 50B motion unless there's been a 50A motion made during trial. No 50B, then no 50A. Excuse me, my bad. No 50A directed verdict, then it's impossible for the court to grant a 50B J&OV. This, A, is a prerequisite for B. No A, no B. The second is the scope of a 50B motion for judgment notwithstanding the verdict must be the same as the 50A motion. So the substance of an after-trial motion under 50B has to reflect what was asked for during trial. And that makes sense when you think about it, right? Why would you allow the movement to spring up and surprise the opposing party after trial? If there's a problem, you don't allow the moving party to wait after trial to raise a 50 motion for the first time. The reason we want them to ask during the trial under 50A is to give the non-moving party an opportunity to cure, right? Defendant moves for judgment as a matter of law during trial, 50A. Oh, no evidence of breach. Judgment as a matter of law, Your Honor. Well, now the plaintiff can say, oh, I forgot. I'm sorry. Bob, please come up and testify regarding this breach. You see? Opportunity for cure. That's the policy. All right, well, that's very briefly the differences between each of these motions in terms of things like the materials, the things we look at, the timing, and the purpose. Let me close out by briefly noting the difference between a judgment as a matter of law compared to a motion for a new trial. All right. A Rule 50 motion for judgment as a matter of law, I just talked about it, I won't repeat that. Motion for new trial could be during trial or after trial. If it's during trial, we often call that a motion for mistrial, all right? Or it can be after trial, a motion for new trial, which might be on the whole case, it might be on an issue, it might be on a defense, it might be on just one claim, and so on and so forth, all right? The standard varies between the two. Federal courts looked at the substantial evidence standard for a motion for judgment as a matter of law. What that means is the court will not weigh evidence. The court will not weigh credibility. The court does not judge who's telling the truth or who's not telling the truth. In federal court, the federal courts will typically look at the evidence submitted by both the non-moving party and uncontradicted evidence submitted by the moving party. Can look at both sides' evidence, in other words. And what it's going to ask is whether or not there's sufficient evidence to go to the jury, right? The substantial evidence standard. And here, to go in detail about the nature of the substantial evidence standard, I'm happy to do off camera with any of you, but I think we're nearing the end of our energy for the day, so I'll take questions off camera, or I'll point to you to resources you can look at, such as the case plan and casebook that you used during law school. Let's contrast that with the weight of the evidence standard used for a motion for a new trial. If the problem that leads to the new trial is insufficient evidence, well then what the judge can do is ask, well let me put it differently, did the jury verdict go against the great weight of the evidence? And here, the judge does have the power to independently weigh the evidence, to independently judge credibility in determining whether or not a motion for a new trial should be granted. There's a subset of new trial motions that come in called remittitor and additor. The difference between a remittitor and additor is a remittitor is when the damages awarded to the plaintiff are shockingly high, and the defendant moves for a new trial on the basis of shockingly high damages. And what the court says is, plaintiff, I'm either going to grant this motion unless you agree to a reduction of your damages. So remittitor, the movement for the new trial is the defendant, and the court now gives a Hobson's choice to the plaintiff, saying either reduce your damages to this, or I'm giving a new trial. That's constitutional. However, an additor is unconstitutional. That would be plaintiff wins but gets very few damages. And now the movement for a new trial is the plaintiff. The plaintiff wants more damages and moves for a new trial. And suppose the court says to the defendant that, hey, defendant, plaintiff's move for a new trial because he didn't get enough damages. So you either increase the damages to this or I'm granting a new trial. That violates the 7th Amendment. Okay? So that's it. And so I'm going to say thank you. I'm going to say thank you and best of luck on the bar exam.